It is April 30th of 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Today we've got a guy trying to convince Judge DiSanto his 10 active warrants are, quote, just traffic tickets. A defendant blaming the jail medical staff for all their issues, and a tragic hit-and-run case that leaves Judge Stevens quite furious. Plus, stick around for a chaotic rapid-fire docket with Judge Simpson featuring a defendant who decided to take a nap during his own hearing, another complaining about the jail menu, and one guy who allegedly licked a police car while getting arrested. You can't make this stuff up, ladies and gentlemen. It's been a nutty day in court, and it all starts right now.
All right, we are on the record in the matter of the state of Michigan versus Daniel Acosta, 26356.
Right here. Good afternoon, Your Honor. I'm sorry, good morning, Your Honor. Neil Blake here on behalf of Daniel Acosta. Please state your name, sir.
Manuel Fernando Acosta.
Thank you.
Acosta. Sounds much better the way he said it.
It's Costa Rica.
Costa Rica. Oh, there we go. Okay.
That's
All right.
She explained it to me. She said, "You want me to tell you your last name?" I said, "It's Acosta." She said, "You say Costa Rica?" I said,
Okay. All righty. And thank you for dressing appropriately for court. Grant must have told you that too.
"Thanks. That's what. Got over dollar." He guaranteed that he would. He bet me that he would say thank you for dressing well.
You've got to come with on this jacket.
Thank you.
Trust me.
Maybe I'm too predictable. Okay. So, all right. And so then, counsel adds to the arraignment.
Yes, my client waits formal reading is to be there.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then as to the pretrial.
Yet had an opportunity to review this with my client as well as with the Wayne County prosecutor, Mr. Muhammad. After reviewing that, my client was prepared to offer guilty plea to essentially its counsel on the driving license suspended the enhancement, they count two, but the enhancement would be dropped.
Okay. And so, Mr. Acosta, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
Okay. And you heard the plea that was placed on the record, correct?
Sure.
As to the charge of driving while license suspended first offense, how do you plead?
I'm going to be guilty.
You've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
And you understand all of those rights.
Yes, Your Honor. I do.
You also understand, sir, the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes, Your Honor. I do.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor. I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
Not at all, brother.
Any immigration issues?
No, I'm not.
All right, counsel, if you can please argue your client.
Yes, I will. Mr. Acosta, do you recall being in the city of Wyandotte on about the 22nd of February of last year?
I clearly do.
And at that time, you're operating a motor vehicle,
Yes, I was.
and you had an interaction with Wyandotte police officer.
Or I'll claim bloody, yes.
And during that interaction, it was determined that he did not have a valid driver's test.
Yes, I let them know all front things.
Yes. All right. And you understand what the judge is explaining, that there are over and above what the criminal things may be here in this side of this court. You have issues with the Secretary of State. You understand there's additional suspension, there's points and so forth that are controlled under the Secretary of State's regulations. So you're aware of that. Right?
Yes.
And knowing that you're really voluntarily pleading to the driving license suspended, right?
Yes.
Your Honor, I'm satisfied with that.
Okay, the court is also satisfied the plea is knowing, voluntary, and factually accurate. Bless you. The court will accept your plea, dismiss the enhancement,
Thank you.
Are you looking for immediate sentencing?
Oh, yes, sure.
Yes, sure. If you don't mind. I need to get this behind. I'm ready for clean slate and they can't do anything with me. So it's not.
Wow. Great. I'm really looking forward to hearing what Mr. Du Bois is going to say on your
Well,
behalf.
because you think very eloquently explain his circumstances, but he has conveyed to me that he's got children he's raising. He's very busy. He's got to get his life in order. This needs part of that. This business of getting his license sorted out. This has been pending now over a year. He's coming to take care of this. He's not on probation. Roll anywhere. He's got no cases pending in the court. He did put $500 bond in this case. This isn't random thinking. He wants to go forward. He wants to get this cleaned up. I understand there's going to be some additional suspension from the Secretary of State.
For a year.
He's got a driver today. Didn't drive here today.
Who's your driver?
Well,
Married to the aunt that told you how to pronounce your name?
what's that? No.
Oh, okay.
No. That's May, big influence on my life over the years. Done that for me. I'm born and raised in Detroit. I have a 23-year-old son. Goes to LA Film and Music. I run my own company for 24 years now. I started off, my tickets weren't paid, so it just got suspended.
Well, I think the third offense, drunk driving, wasn't helpful either with your
You
license.
want to know why I got those OWI? I actually,
Sir, I don't want to know about that. No. I'm just saying that also wasn't very helpful in your licensing.
no, because I didn't have a license is the only reason why I got those OWIs. I believe .07 and .061. I wouldn't have got that if I would have had my license. I would have gotten it. But
Well,
that is what it is. It doesn't help. You're correct. And when I read in front of the review board, it didn't help.
right.
So, yeah, most definitely.
So, well, point of clarification, this hasn't been pending for a year. It's been pending since August 22nd of 25.
August, I have February date. I'm sorry.
That's okay.
Oh, that's my son. Wait, that's my son.
So, sir, aren't you tired of going to court all the time?
Your
Did
Honor,
you just girl me?
Your Honor,
He just girled me. Okay.
my apologies. Your Honor,
At least you didn't.
I've been tired of this life my whole life. I was told that a license was a privilege when it's a necessity. I had a child at 19 years old. I've been through a whole lot in my life. I could go on a list. I've been doing well though. I've been an actor for the last 8 years. I've been in over 60 films. I've been in front of the review board to try to get. I stopped driving for my son being 12 to 19 before he started college. I literally did everything. I got paid $46,000 a year for somebody to look at me dumb and argue with me about making rights and less. I want this over with more than you want to deal with. I've been trying to get a clean slate, so I had to clean this up before I could do it. I've been working. I went in front of the review board. She asked me if you drink, would it be okay? I said, yeah, I'd be okay, but I have no desire to. No license. I've done
So I think that the lesson in that is that's not the answer they were looking for.
right, but it was an honest answer. And I'm not a liar. And I will never be a liar, and I will not start lying for anyone. It's not what.
Great. So why were you driving on August 22nd of
Because
25 in the city of Wyandotte when you have not been driving for a long time? In fact, there's a big gap of driving offenses
Right.
on your lengthy criminal history of driving offenses.
I stopped driving for, like I said, for my son being 12 to 19. When he started, COVID hit. When he started college, it was the same time COVID hit. My drivers disappeared. Everybody disappeared. Everybody got 3 checks and didn't want to work no more. I started the wrong way. Nobody taught me how to run a business. I did it all on my own. I worked all the way up. And yes, my life was a mess.
Hold on, but
So-
that's,
so good,
sir,
good.
you're not answering my question. I'm glad to hear a little bit of
no,
your.
I was driving
I'm glad,
before
I'm,
working.
hold on, I'm glad to hear a little bit of your history.
Yeah.
But you're not answering what my question is to why you're driving August 22nd of 25.
Yeah, I was working. I run a 24-hour heating and cooling business. I was driving. I was about to stop at the Zorba's to get something to eat because it was about 1 o'clock at night. I go all day and try not to eat fast food. So I was stopping to get something to eat. They pulled me over because my plate light was out.
Why didn't you just have one of your employees drive you?
If I had employees, if I could keep anybody, my life is not, I'm tired of that. There's no excuse, Your Honor. How about that? There's no excuse. There's no excuse. There's no excuse. I drove. I knew I shouldn't have been driving. I drove. And I'm guilty, and that's why I'm pleading it.
Okay. So where are you at with your clean slate stuff?
They told me take care of this and they can take care. That's what I cannot.
relation to what?
What's that?
They're going to take care of what?
They'll fund my whole record. They're gonna give me my license back and everything. Operation Clean Slate is gonna take care of everything. They just cannot do it until this case is closed. So,
Do you have any other pending cases?
no, I do.
So, your uncle drives you everywhere?
No, he does not. I have drivers. I just don't have nobody consistent. Everybody works when they want to work. This whole generation's.
Well, you don't have to tell me that, sir. I'm very much aware of that.
I'm just looking down and not even giving no words. I'm like, you already know what it is. Like all I can say is I'm guilty of driving. And I'm doing what I have to do to support my son. I pay his rent, I pay his tuition, I pay $700.
He should be driving you around for no charge then.
My son is gonna do better than I've ever done, and he already has. He lives in LA, a half a block.
Oh, I guess he can't do much driving for you when he's in another state.
And you know what? He's chasing his dream and doing well at it. He's producing, mixing, and mastering things. Then he does Christian music and already dropped his album before he even started school there. So now, everything I do is for my kid. Everything I've done, even building this business and driving that all hours in the morning. The only reason I can tell you why I got pulled over, scrapped my van, transferred my plate. They pulled me over because they knew I didn't have a license. It said it right on the plate. I didn't learn that until I stopped driving. But it is what it is. This has been my life. I've been doing the best I can do. I used to not show up to court, not show up to court. I've taken care of my business the best I can. All I can say is I pay $2,200 a month just for my son to live and go to school. And that's my biggest priority. And I've been acting the last 8 years. I've been over 60 films too. I've been working on my way up.
Okay, and that's fantastic. And I can appreciate that your son and supporting him is your priority. However, your priority should really be focusing on not driving so that you're not having to pay more money in fines and costs to courts.
I wish it was that simple. I've been in predicaments that I shouldn't be in, and I've been having to make choices that I have to make that up.
So let me ask you this question, sir. First of all, you're correct. Driving is a privilege. We just happen to be in a region that public transportation is not necessarily prevalent nor convenient. However, you're aware of rideshare, correct?
I run a mechanical contractor business. I don't have that option. I run a 24-hour heating and cooling business. Rideshare is not going to give me job to job customers who've been with me for 23 years. It's not as easy. So I do have drivers now, and I haven't been driving. All I can do is that until I get this clean slate done. So I'm not driving. That's all I can tell you.
Very good.
I can't do anything else but not drive now and get this clean slate done and get this fixed.
Right.
Or else I would have tried to fight this even down lower, but I just want this done and over. I paid a $500 bond. I said, bump it, I usually act appropriate persona, so I can talk to the attorneys, the prosecutors myself, and the judge myself. I usually don't even use a lawyer, but I allowed him to step. I just want it
He just wants to look good right next to you.
so I just want it over with so I can get this part of I've been trying to get, I stopped driving for 6 years. Pull my hair out, pulling $30,000 to $46,000 a year for somebody to tell me you didn't tell me to make it right. Like, trust me, this is not where I want to be right now.
Right. So I think something that's very clear is that drive again, you're going to just continue to prolong getting your license back.
Exactly my
In the grand scheme of things, your license being suspended for one more year is a small amount of time in the grand scheme of the number of years of life.
And I've done this before, and I'm doing it now. So it's not like I haven't done it before. I did it for 6 years. 6 years. I do everything I can the right way.
Okay.
And sometimes I did.
So here's what I'm going to do, sir. I think my math is correct. I'm going to order a $200 fine. Well, first I'm going to find that there's not reasonable grounds to depart from MCL 769.5. Wait a minute. Your company, where's your company located? Right?
It's out of Detroit, 1449 over there, Detroit, Michigan.
Okay.
226. And I just opened the second one in Brighton.
Okay, and you live out in Brighton.
That's mine.
Okay, so where are most of your jobs?
Everywhere. I go 3 states wide. I go all the way. I just did a job over in Chicago, in Illinois, in St. Charles, Illinois, at the golf course, one of the golf courses over there. I just did the whole event hall with spiraled up and everything. I
Okay.
go where they call
Okay. I'm going to order a $200 fine, $175 cost. Crime victim assessment fee of $75, justice system assessment fee of $50. My math says that's $500.
Yes,
Is that correct, Mr. DuBois?
I wasn't double checking.
Okay. All right. We're in a triple check here. Yep. There we go. $500 total. So you don't have to pay any more money, sir. Stop driving. Stop driving.
I'm not getting my coins. I'm done. This is the last case I had to take care of. And I didn't get called for years until my divider got taken out for that job in Chicago. That's when they started.
What got taken
I
out?
had to take the divider out to load my van up.
Well,
And they started pulling me over, I think, because I didn't have the divider, to be honest with you. So the only time I ever got pulled over is when I took that divider out.
Zorba's after 12 o'clock is usually a magnet also. So
I'll play like, I don't know why. But it is what it is. God wanted me here. That's all it is.
and we got to meet Mr. Acosta.
Yeah, there we go. Go to me and see all three up in it, but put the Fernando in there. That's my papa's name and his father. My grandfather and his father. So
Okay, Daniel Fernando Acosta. Okay, good luck to you, sir.
God bless you. I appreciate it.
Thank you, Art. Take care, sir.
Just remember, as your attorney will tell you, I remember names and faces, so don't come back.
Oh, I don't forget.
Unless you just want to come visit.
Girl, the last time I was up.
Girl, I got girls again.
You're right. The last time I was up in this place, there was the old side. I was the last
Oh, where Starbucks is?
old jail, and then I came back to finish my case in the new jail. So it's been a long time. Trust me.
Okay,
All right, then.
you too. Okay, so we are on the record in the matter of the state of Michigan versus Jeffrey Campbell, 26286. I'll handle that in just a little.
No, I just want to know.
Um,
I got it done. Thank you.
All right, and so counsel, your appearance, please.
Good afternoon, Carly Kavanaugh, the 862. Mr. Jeffrey Campbell, who's appearing from the Wayne County Jail. Mr. Campbell, if you can please state.
Jeffrey Campbell.
Okay, so good afternoon. Today is the date scheduled for sentencing on your client's plea to the charge of controlled substance use. The original charge of possession of controlled substance was dismissed by way of resolution between counsel at the probable cause conference. And counsel, did you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor.
Are there any corrections that need to be made?
No.
All right, and then as to the recommendation.
Your Honor, I am asking the court to adopt the recommendation for probation today. My client has been incarcerated for approximately 58 days now, Your Honor. He's been in there since I believe the date of the incident, which was March 4th. Your Honor, I am asking the court to adopt that recommendation as I do believe it is appropriate. My client does not have really much history with the court. He does have some traffic and I think some outstanding warrants with other matters, but he does not have any history of drug cases or felonies, Your Honor. This is his first drug charge, so as such, I am asking the court to sentence him under 7411. I do believe that is appropriate, and he is eligible for that, Your Honor. He does have a history with using, Your Honor. He's admitted that he was prescribed medicine from knee injuries and things from playing hockey years ago, and it really got out of control and continued down that path. So, Your Honor, he is admitting that he has some substance abuse problems. He's already taken responsibility before the court. He does have 4 sons and a grandson now as well. I believe his children, 2 of them are adults, but 2 of them also still reside with him. He's been at risk for losing his home. I know that the children's mother's been in contact with me regarding that. So hopefully if he's released today, he'll be able to, keep his home and get his life back on track. He was working at Firestone in Taylor prior to being incarcerated, Your Honor. So he's hoping to get back there. So I asked the court to adopt the recommendation and sentence him under 7411.
Okay, so Mr. Campbell, it seems as though there seems to be a little bit of a family affair going on with some things.
Family affair.
Right, your uncle, Keith.
That's not nothing to do with me.
What's that?
Keith Campbell has nothing to do with me. He's my
Really?
uncle.
Because your statement to probation was that you picked up the crack cocaine for your uncle.
Right. But he has nothing.
I said, a family affair.
Okay. Yes.
So it does have something to do, sir, just a moment. It does have something to do with both.
Yes, I thought you had me confused with Keith Campbell. I apologize, Your Honor.
You thought what?
I thought you were talking to me as Keith Campbell and like Tracy Anderson. I thought you had me as
No, I said he's your uncle.
All right.
So, sir, tell me about your 10 warrants.
They're all traffic tickets, Your Honor, and then the one in Lincoln Park is Suboxone. That's the warrant, the Lincoln Park one. That's the one I'm going to do next. I gotta take care of that as soon as I get up out of here. The rest of them are all just traffic tickets and warrants or traffic.
Okay,
warrants.
so just traffic tickets, sir.
I'm taking care of them.
No,
I need to take care of them.
You're minimizing it, sir. You're 100% minimizing. Just traffic tickets. You still have warrants because you failed to handle those. 36th district from 2023. No insurance. 33rd district court, 2025. Driving while license suspended. That's not a traffic ticket, sir. You failed to appear for an arraignment pretrial from 23rd district court. That warrant was issued in March of 25. It doesn't say exactly what it was, but you didn't appear for an arraignment pretrial, so that tells me it's not a traffic ticket.
No, that's my Suboxone. That's the Suboxone one.
That's Taylor, not Lincoln Park. You said it was Lincoln Park.
Yeah, Lincoln Park. Yeah. Go ahead.
23rd district court, March of 25. No proof of insurance. You failed to appear. Also expired plate from the same one. Then July of 25, you failed to appear for another arraignment pretrial. So that tells me it's, again, not just a traffic ticket.
No,
Then you have a distracted driving that you failed to appear for or pay on out of 23rd district court. That's just a traffic ticket. Then we have, here's the dangerous drugs. Your date of the warrant was February 2nd of 26 out of the 25th district court. And then again, you failed to appear for another arraignment pretrial in 23rd district court in Taylor. And just one moment. Then you also have another warrant from February 11th and 26 from just a traffic ticket in Lincoln Park that you owe $700 bond on.
I apologize for calling them just traffic tickets, Your Honor. I understand that they're warrants. I have to take care of them. I'm going to take care of them as soon as trust me. I learned my lesson being in this jail. I am not coming back here, and I'm going to take care of those as soon as possible. I need to get back to work. I got to take care of my house and my car. I'm a single father of 4 boys, and I paid my house. I'm losing my house as me in this jail right now. So I had to drive my car with no insurance to work because I'm a single father with 4 kids. I have put in hockey, and I have to pay my rent and my bills. That's the reason why I was driving those cars anyways at Taylor and picking up medication for my grandma for illegal, in Southgate and all that other bull crap. So I apologize to you and everything else.
Sir, clear up your warrants. So if your kids doing house hockey or travel hockey?
Travel hockey.
Okay, then perhaps you need to tell them they can't do travel hockey and they have to do house hockey because you don't have the funds to pay for travel hockey. You can take care of all of your other matters so you can have a valid driver's license, sir.
No, they got sponsorships, so it's not me. So
then don't use hockey as your cost, as your expense excuse.
I said my bills and my house payment. And
you also said hockey.
Your Honor, I think his reasoning for hockey was driving. His kids do hockey.
Okay.
Yes.
Okay. And so just to be clear, your warrant out of Lincoln Park is for felony possession or sale of dangerous drugs as well as paraphernalia.
It was a Suboxone, Your Honor. That's what it is. And I remember talking to the detective instinctively. He told me that he couldn't find my doctor that was a Suboxone doctor, which I've been going to this doctor for 5, 6 years now. So I don't know how you didn't find that. I'm taking care of that.
Okay.
She left it out of here.
Do you have a valid medical marijuana card, sir?
I used to, but I haven't had one in a couple years.
Right. But you're still using it every day when you're not in jail?
I don't use it every day, you know. I haven't used it like in the past 2, 3 months, to be honest. Since I've been incarcerated, 2 months before that, I haven't used it.
Well, it says you reported that you use marijuana daily, but you do not feel as though you have a problem with marijuana.
Yeah.
And then it also says you stated that you do have a valid medical marijuana card.
I had one. I never said I had it. I said I have to renew it.
Okay. All right. So here's what the court's going to do, sir. The court's going to give you an opportunity, sir, to try to resolve your substance use issue. Although, counsel, it might make sense if we adjourn the sentencing, your client handles the Lincoln Park matter, and then potentially he can go into drug court with both cases.
I don't necessarily disagree, Your Honor. I guess I would just request a bond to have my client.
Right, I would do that. So here's what the court's going to do. The court's not going to sentence you today, sir. The court's going to indicate, we'll adjourn this out. For your potential participation in the 25th District Court Treatment Court, along with the 25th District Court case that you have pending. The court will amend your bond to $20,000 personal bond with a GPS tether. Given your history of failing to appear,
That's fair.
well, good, thank you. I'm glad that you agree with that, sir.
That's fine. Goodbye.
All right. Now, whether or not he can still get released because of the Lincoln Park warrant, I'm not sure. But in any event, at least he'll get that resolved.
Absolutely, Your Honor.
Okay. All right. So balance of bond conditions continued. All right. And then you'll get a new sentencing date for here. And so then, counsel, you may want to just chat with probation when you're back there with Mr. Bethia as to that. Okay.
Thank you.
You're welcome. Good luck to you, sir.
You too, man.
All right. Have a good day. Thank you, counsel.
All right, Your Honor. Have a great day.
Thank you as well.
Demond Sargent Jr. is first. Is going to be here for that. We got 2 cases. And T-shirt, that's what you got. That's what you got, a T-shirt. You're looking at a total of 30 years in prison. Right? And you think your life's future, like that's your best foot forward, a T-shirt. Look around everybody else. Look around. You see ties. The guys have ties on them because it's a place of importance, respect, the Constitution, important things. They may not be important to you, but they're important to most people, and they're supposed to be important for everybody. Maybe that's why you're here. The rules aren't important, but you're going to be held accountable because people do think they're important. It's the way we live together peacefully so we can all enjoy the blessings of liberty. All right. What is the issue today? Something about
Pat,
it.
you just pulled the second piece of paper you have in there, just the highlighted area.
All right. Did you get a copy of this?
I did yours, and I have it in front of me.
All right, well, it looks like last month, a drug patch was collected and showed positive for cocaine as a result of the testing. Okay. Anybody wants to say anything?
Yes, Your Honor. So my client just recently was released on bond, and while he's in the,
When?
I don't remember the exact date.
Let's find the date. Okay, whatever that is. Anybody know?
I'll look up this.
But while he was in
Let's find the date
yes, sir.
so we can go off some things that are certain.
It was a recent bond. All that show was from 2024.
It
No,
was released February 27th to 26th.
a little over a month.
Okay, I see it now.
Yeah.
Okay, go on.
Thank you. So while he was incarcerated, Your Honor, he was on some medication, and then when
Okay,
no,
they had him on cocaine?
no,
Okay.
but it wasn't a medication for mental health. And when he was released, that he didn't realize it was showing up on his drug patch until I notified him. When I was notified
What
by the
was
court,
showing? The
that
cocaine?
anything was showing up in his system.
Well, I mean, how's that supposed to be until something is collected and then tested and analyzed and then reports back to us?
Understood.
But
But since then, Your Honor, his drug patch numbers have gone down. The last drug patch showed clean. And immediately when I notified him of the drug patch results, he went and on his own and had a UA and a hair follicle, which he does have with him today, that both showed he was clean. So he did do the best he could to show.
what was the
you.
date of that?
I'm blind, Your Honor. Give me a
That's
second.
okay.
Which one is the hair? Here's the hair follicle right here. It was collected on April 17th, and the report was issued on April 24th of 2026. Would you like to see it?
No, your word's good enough for me. But on this collection on March 13th, he had been released from jail.
He had. The same week, he did go take a drug test for employment and passed with flying colors, which is also one of the documents in here. I think so too.
Um,
This would be the drug test he took for employment during the time of the patch.
And he had been released from jail when?
February 26th or 27th
27th, February 27th.
of 26.
Okay. So how do you explain the positive in March?
He believes it had to do with something that was in the medication he was taking at the jail. There is a log of the medication as well.
That's what he believes
That's
from
what he
his
believes.
medical experience
Yeah,
and
Your Honor.
medical training.
Yes, Your Honor.
Anything from the state?
No, Your Honor, I don't know what medications he's taking and hadn't had a chance to even look and see if anything like that has any false positives.
Here's a list. I don't know if any of that rings a bell for you right away, but that's what he was issued in the jail.
I don't know anything that does test positive as cocaine metabolites, but sure I'll just continue.
Here's the problem with all of this is that nobody's given me anything about what he's supposed to be taking, but what he is taking and why. But the fact of the matter is that he tests positive for cocaine. So far, what I've heard, all I've done is open a door for everybody, everyone to come out of jail and test positive and say, I want the old Demond Sergeant rule. I may or may not have been given medication. But the point is if I test positive, I'm going to use his rule and presume that it had to be something that the jail gave me, which I don't know and I can't answer to because I don't know what they gave me.
Well, he
The
did.
problem is that it tests positive. He's going to be held accountable. I can always, he's going to be held accountable. His bond is going to get revoked on this. It's just the way it is. If you want to get some more information, I'll open this door up for another hearing from experts, anybody you want from the jail to revisit this. But unless something else happens, this is the way I'm going to rule. I'm not going to presume that the jail is giving them cocaine so that they can test positive a few weeks afterwards and then claim it's the jail's fault, not mine. Period.
Let's say ibuprofen until I looked it all up.
Apparently,
What's his bonds in each case, please?
Judge, on the assault is $110,000, and on the harassment, it's 40,000.
Okay. You test positive for a controlled substance, cocaine. That's a second-degree felony.
My hair fall.
And your bonds are doubled.
his hair follicle did come back clean.
Let's see, 90 days.
When?
Just in April.
A month later, ma'am. Not when this test was taken, a month before.
He did have some employment tests that came back clean the week it was taken. The patch was taken.
I trust these people. That's who we use. People who are, I can hear something, please leave the room. When you disturb this court, leave the room. Kendall. I'm gonna have, yeah. We're doing business here. This isn't a cry fest.
Other way.
Hey, ma'am.
Other way, ma'am.
Ma'am, your outburst just made you in contempt of court, ma'am. You can be placed in jail for up to 6 months. Would you please just be polite? Thank you. That's all we ask of people. Be polite. We're taking care of serious business up here. People don't like what happens, and so they make an outburst. You can everybody know that's the rule. You can be held in contempt of court if you make an outburst and disrupt the proceedings. Please don't do that. I don't want to put people in jail unless they're necessary. I made my ruling, so you had cocaine in your system. It's a scientific test, and the court does not believe the explanations y'all have given. So I'm presuming the test is correct. Your bonds are revoked. You're in jail, and you must have a drug patch if you post your bond. Period. End of ball game. What's next? We set this for trial or what?
Yes, Your Honor.
Is that what we want to do on these?
Well, I haven't had a chance to speak with counsel today on
Yeah,
that.
how about an announcement in what, 2 or 3 weeks?
That would be appropriate.
Because maybe something could get disposed of to move him along, get him back on his feet.
He is working or was.
Well, of course, he'd have to, because of this, I mean, we'd have to test him to make sure that he's negative. If something is fashioned to where he would be released.
Yes.
But he's got to pass our drug test to get released. What is his criminal history?
He has no history.
You have no criminal history? Sir?
It's the minute.
No, I'm talking about felonies.
No felony.
I've said this for 2 weeks, sooner. I'm always open for business to try to work this out, especially because he doesn't have a criminal history.
Thank you, Judge.
You know what I mean?
Right.
Okay.
Yeah.
Oh, thanks. Yes, ma'am.
Let's see.
Okay. This is 24 CR 1338, the state of Texas versus, correct, sir? Mr. Medina. Mr. Rojas is here representing you. Earlier in this case, you pleaded guilty to collision involving serious bodily injury or death, which was a third-degree felony, which carried with it up to 10 years in prison. An agreement had been reached when you entered. And has he entered his plea yet?
We have, Judge.
Yes, sir.
Because it's not showing that
Back on March
on the
19th.
file. I don't even have anything on it here. What was the date?
March 19th.
Yes.
A pre-sentence report has been prepared and the parties had an opportunity to review it.
We have, Your Honor.
And are there any corrections or changes to this?
Not from the state.
No.
No, Judge.
You believe it? I believe it's a valid partnership.
Then it's made a part of the record for all purposes. Has there been a determination of restitution? How much?
No, sir. I don't have anything, any correspondence. You know, if I saw looking on the computer, see if there's something that came in that I didn't know about.
Judge, my client tells me that his insurance has settled with Mr. Jones on whatever portion they're responsible for. I don't know if those policy limits or not. There may be some amount above that.
Is the complainant here by any chance? The victim? No. Okay. Where to begin? The circumstances here are disturbing that in February at approx 2024, which would have been 2 years ago, a little over 2 years ago at about 7:30 p.m., 7:13 p.m. So that would have to be dark.
Yes, sir.
If not dusk. It certainly was dark. And Beaumont police went to College Avenue F. I guess that's College and Avenue F, an intersection there
Yes,
in
sir.
Beaumont, investigating a collision between a vehicle and a cyclist. And a witness had been following the vehicle involved in this. I guess that's the defendant's vehicle, Ford F-150. And they officers subsequently located, detained the driver who was the defendant, Mr. David Medina. And he confessed to hitting what he thought was a bicycle, panicking and fleeing to his home without providing assistance. Investigation later showed that the cyclist suffered multiple fractures, significant laceration, and was arrested and then ultimately charged with this third-degree felony of a collision involving serious bodily injury or death. And as far as the injury was concerned to the cyclist, he sustained severe injuries requiring approximately 8 months of hospitalization in 2024 across in three separate medical facilities, undergoing a surgical procedure in which part of his skull was removed, as well as the insertion of approximately 25 pieces of metal into his hip. Due to the severity of his injuries, he's no longer able to return to his prior employment as a carpenter and is now significantly limited in his ability to earn an income. He is currently trying to work for Uber Eats, but is unable to achieve comparable earnings to his previous employment when he was not injured, and that he has an ongoing financial hardship that has resulted in his current residence in a homeless shelter of all things. Let's just get sadder and sadder the more you read. All right. What to do? The agreement here is whatever sentence shall not exceed a cap of 8 years imprisonment. So you were looking at no less than 2, no more than 8 years confinement in prison. Can I give him regular probation?
Yes, sir. This is not a one you do the deadly weapon finding on because
There was a vehicle
Yes,
is in its use and it caused serious bodily injury. It means it fits a deadly weapon. So we're not foreclosed.
you're not, because it's not you cannot make a finding of a deadly weapon on a failure to render aid.
And then there
collision.
could be deferred or unadjudicated probation.
Yes, sir.
Is that what you see, Charlie?
Yes.
Thanks. All right. Go ahead, state.
Judge, looking at the victim saying 8-year sentence is not enough, well, the most we can give him is 10, and giving him credit for taking responsibility is at least now and pleading guilty and confessing to it at the scene. I thought the 8-year cap was appropriate. I still think the 8-year sentence is appropriate in this because just leaving somebody there with those injuries, he could have died and it could have been a 2nd-degree felony. Then we would have been looking at something else, possibly manslaughter charges, things of that nature. But because of the way the grand jury indicted it and looking at the seriousness of the injuries, 8-year sentence is pretty light, but it is within the upper range of the actual offense charged. I just can't imagine leaving somebody there on the side of the road, no matter how much you fear the cops. It's just your instinct is to just stop and help somebody when they're hit, and he just took off. So we would ask for 8-year prison sentence.
Go ahead.
Judge, certainly his injuries, Mr. Jones' injuries are severe. Mr. Medina made a terrible decision to leave the scene. I don't think anybody can argue with that. If you look at Mr. Medina's statement, he panicked and went home, and his intentions were to call the police. It's just the police got there before he could make that phone call. We're asking the court to consider probation. He has accepted responsibility, accepted once the police got there, he didn't deny that it was him that was driving the car. He readily accepted it was him. He's coming to court and pled guilty to it, Judge. Mr. Jones is asking for restitution. As I say, Mr. Medina's insurance is paid. I don't know. I don't have that information in front of me. I would believe policy limits about $30,000. Certainly his bills are more than that. To be in the hospital for 8 months. Mr. Medina is working. He's always had a job. He's working construction now. He would be in a position to make payments towards restitution. The court could order that payments go first to restitution, then if we were to put him on probation, to try to make some restitution to Mr. Jones so that we can hopefully give him a little bit better life than he's got right now, which he certainly deserves after going through this. Mr. Medina has a limited criminal history. He's got one case where he was on probation for marijuana and deferred adjudication. Looks like he successfully completed that. As far as I think that's the only adjudication that he's got in the pre-sentence investigation. He has a support system. Both parents are available to him. He has a sister that lives here in Beaumont, and it appears that they get together regularly. They are able to support him in any way possible. We're asking for a chance on probation, Judge. I looked at the PSI. It looks like they're recommending that if you were to give him probation, safe P. And if that's something the court wants to do, obviously we can't complain about that. He just is asking for a chance to continue his life, make restitution payments to Mr. Jones.
How much is the restitution?
I don't have anything.
There's no amount.
Mr. Jones.
It's that's something probation can determine at some point.
I think the victim in this case wishes restitution, but there's nothing based that I have a basis to order, except to order restitution in an amount to be determined, I guess. But
And it doesn't look like, I think if probation is to determine restitution, I don't think they have a problem getting in touch with Mr. Jones. He gave a pretty detailed statement.
I'm going to ask that no matter what happens, restitution is going to be ordered in an amount to be determined. But all the parties agree that restitution is owed here, and it is going to be ordered in some amount, but I can't just say a number now because there isn't anything here that causes me to be certain, and I want to be accurate, and the victim needs to be heard into as to how much he's going to he needs to receive in his losses, based upon his losses. But anything else?
No, Judge, but I think Mr. Medina would like to make a brief statement.
Go ahead, sir.
Yes, sir. I understand that I did wrong.
What did you do wrong?
Leaving that man.
Why did you do that?
Just not scared.
So you knew somebody had been injured, somebody's laying on the ground, and you just drove off?
That's correct.
Sir?
That's correct. I
I'm
wish
glad somebody didn't run over him after he had been injured. He's just laying on the road for others to clean up the mess that you had caused. That's so inhumane.
I understand.
Okay.
I wish I would have done things different.
Well, but the police arrested you later that day? How long after the event?
Even maybe an hour.
Half. But up until that time, you weren't about to turn yourself in, right?
I would. Yes, sir.
You didn't. Apparently 30 minutes with somebody knowing someone was laying on the ground that you had caused injuries to, that, and for a half an hour, that didn't bother you to call the police and say, it's me. What do I need to do? They had to come get you, right?
Sir.
Yes. Okay. It's a bad thing altogether. All right. Anything else?
No,
Here's what the court's going to do. We have a multi-level set of circumstances here. This is like a bar exam, because there's different dynamics involved in this one. I'm going to find that you, Mr. Medina, have pleaded guilty to this third-degree felony of collision involving serious bodily injury or death in this cause number. You have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in your plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony. Now, the agreement is whatever sentence shall not exceed a cap of 8 years confinement, which puts the court in a position of 3 different options: deferred or unadjudicated probation, which is foreclosed now because I have found you guilty of this felony beyond a reasonable doubt. We have regular probation up to 10 years in length, and confinement in prison. The state is asking for confinement, and your attorney is asking for probation. The state's request is certainly reasonable.
it's also based upon what the victim wants to, Judge. Complaining in the case.
Here's what, and I've seen this, the victim has all, between his physical problems and his monetary loss, he is in a bad situation. Here's what the court is going to do. I am going to sentence you to 8 years in prison. Everybody listen and hear me out. That will be suspended. You were placed on regular probation for 10 years. Number one, as a condition of probation, I can place you in a jail for 180 days. I'm going to do that. You're going to have to do 6 months in jail. After that, you are going to go directly to a substance abuse felony punishment facility and complete a substance abuse program. You will also be ordered to pay restitution to this man, and it'll be whatever his full losses are that are still that we all the parties agree are necessary, but are not determined at this time. Your statements here in this pre-sentence report about your let's see, marijuana use, which is overwhelming for years, daily, from the age of 15 to December 2025. How old are you now?
32.
32. 17 years of marijuana. Cocaine from 28 to December 25, frequency on weekends. You're also going to do this. You're going to be ordered to fully cooperate with law enforcement on the sources of these drugs that you have acquired, and you're going to take a polygraph test. And if I catch you lying, that'll be another reason that could be used where your probation could be revoked. The state's request is certainly reasonable, but you need some other help as well as confinement. And you're not going to get it by going to prison. And the poor victim here needs his value and his expenses paid, which are going to be thousands of dollars, which you're going to be responsible for, which you would not be if you go to prison. But you're going to be in a facility, a prison-like facility, for at least 9 months, which is maybe less than what you deserve from what the victim's problems are. You've made a big mess here, but the biggest mess is your decision to use drugs illegally. And every one of those instances is a crime in itself. So every one of those, and you're doing it for years. You've been doing it for years, but between cooperating with law enforcement as a condition of your probation, going to confinement in jail for 180 days, which is the most I can order, and going from there directly to substance abuse. I don't want his feet touching the ground until all of this is accomplished, and you cooperate with law enforcement and they send something back to me that you have been that they're satisfied that you cooperated. Those are going to be included with the conditions of the other conditions of probation that we normally assess.
Do you have orders, Judge, that probation's asking if you have a set of orders underneath your file? Is this underneath your file here? Is this?
Oh, I'm sorry. I know. I didn't over here. Well, they always send it to me. Here's some special, you have special conditions as well. Substance abuse felony punishment facility special condition. I'm signing on this day. There's no fine because the restitution is going to be.
Thank you, Jeff.
Is going to be. I'm putting TBD to be determined.
Yes, sir.
Also 180 days.
Yes, sir.
And when do we begin this? You report in Friday,
Right.
on or before 6 o'clock p.m. You understand, sir? It'd be.
This
it-
coming Friday? May first.
There's 31 days in April, right?
30.
Yes,
30.
30
in April.
Yeah, okay, tomorrow's Friday. Okay, got it. So you're gonna check all of this.
Yes, sir.
All I'm saying.
And once you sign all those orders and they get sent over to the jail, that safety hold will be placed on him anyway.
Yes,
So once
sir.
he completes that 180 days, he'll have that hold. So he won't be able to step foot off the ground.
Yes, sir. Thank you.
Yes, sir.
Explain. Anything else?
No, Judge.
That is all.
Court calls the case, People versus Mohammed Diane.
People.
Mohammed Janet.
Good morning, Your Honor. Assistant Public Defender Davi Lebo from Mr. Diane. And Your Honor, I do have a green sheet. Unfortunately, I've not been able to meet with Mr. Diane. I have reached out to the prison where he's housed, but I have not heard back yet.
Can I get a breakout room with you? They tried to have you call me at 8:30. Nobody called the phone. That's why I couldn't talk to you.
I'm not gonna do a breakout room, but when are you gonna be able to get up there to see him?
Your Honor, I'm not sure. I sent the prison an email on Monday with a visiting application, but they haven't gotten back to me.
Simpson, Your Honor Simpson, they was trying to do a call with me with him at 8:30. Nobody called the phone, so I was waiting here to talk to him on the phone. But that's why I was saying breakout room real quick. But I didn't get to talk to my lawyer, and I need to talk to him because I don't even know.
I understand what you're saying, but I'm not gonna do a breakout room. You may want to call or have the public defender's office call regarding that 8:30 call. I get it, but what I'm gonna do is I'll set a probable cause I'll adjourn this out to May 21st, 2026, 9 a.m. And you guys got to figure out a way to get up there and meet with me.
Your Honor.
Court calls the case, People versus Michael Payton.
Stephanie Cantor on behalf of Mr. Payton. He needs hearing assistance.
Your name, sir?
He needs hearing assistance. They're getting the thing. I want you to say your name, Mr. Payton.
Michael Payton.
And Your Honor, we're asking that this be set for a preliminary exam.
All discoveries complete.
To the best of my knowledge, yes.
All right. People will have their witnesses available. We're 12 on May 12th.
No objection.
Preliminary examination then would be set May 19th, 2026.
Your preliminary exams will be May 19th.
Me.
Okay.
I don't know why she did that then.
Because
I know. I don't know why she did it. I know you
put a question.
No, don't even try it again.
I'm sorry, Your Honor.
All right, I'm gonna try this again. Preliminary examination, May 19th, 2026, 9 a.m. That's for me. Okay?
Okay.
You get all that?
Yes, sir.
Didn't have to do that again.
I did.
Okay, bond will continue. Thank you.
Let me take this from you. I'll come see you before then, okay?
Yes, ma'am.
Court calls the case of the People versus Stefan Bruce.
Morning, Your Honor. Raymond Cook for the people.
David I. Goldstein and Ring on behalf of the defendant. Your Honor, Mr. Bruce just arrived. We can pass this for a few minutes. I need to speak to him.
Why was he late?
I think he went to the wrong court. He texted me and said, the door's locked. And I said, you're in the wrong place.
I'll pass him. Court does call the case People versus Darius Cadell.
Your Honor, Raymond Cook for the people.
Yeah, that one.
Good morning, Your Honor. We have ready Matthew Mansour on behalf of Cadell, who stands to my right. Darius, can you please state your name for Judge Simpson?
Darius Cadell. Thank you.
Your Honor, I have a green sheet for you.
Okay. You seeking to adjourn it?
Yeah.
Why?
A couple weeks or 3 weeks, whatever. I just need to keep negotiating, try to get a plea offer.
If I can address bond on his behalf, please.
Probable cause conference will be adjourned to May 14th, 2026, 9 a.m. briefly.
Thank you, Your Honor. Last week we're here, we admitted to the bond violation. He's been in custody for 7 days. The bond violation was that he has not reported to community corrections. I've spoken to him. I've spoken to his mother, who was here last week and here today. That is not going to happen anymore. Lesson is learned. He's 23 years old. He has a job right now. He's had that job for 2 years. He's fully employed. He's hoping to keep that job. He's doing intervention classes. He's hoping to get back on track with that. Transportation is going to be good now. He's born and raised here in Washington. Your Honor, we're just asking please to reinstate the bond to allow him to get back on his feet. There will be no more issues going forward.
Any response from the people?
I would have no option to release one exceeded day. Just testing.
Grant the defendants bond modification in this sense. That is, I'll sentence him on the violation to 8 days Washington County Jail credit, 8 days that he served on the violation, and then his previous bond with its conditions stated.
Right. Thank you, Your Honor.
Court does call the case of People versus Justin Chavez. Pardon?
Good morning, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Assistant Public Defender Davi Lebo from Mr. Chavez. I do have a green sheet. Mr. Chavez, if you could state your name.
Sorry, I think I was muted there. Justin Chavez for the record. Good morning, Your Honor.
Thank you.
Hey, Your Honor, we just received we just discovered this matter yesterday afternoon, so we'd like an adjournment to go over that with Mr. Chavez.
Adjourn the matter to May 21st, 2026, 9 a.m.
Thank you.
Thank you, Judge. Your Honor, if I may, Judge, the defendant posted
yes,
a
sir.
cash bond. I'm sorry, Judge. The defendant posted a cash bond that has not yet been transferred to the child support case. And he also hasn't been paying his ongoing support. So he needs to pay as ordered in May if we're going to adjourn this. And
Well,
I don't know if you can do your magic, Judge, and get that pushed over to the child support
Okay.
case.
Is he paying his ongoing support?
He is not, Judge.
I had just made a payment on the second.
He did
I
make
had
a
made
payment.
a payment, sorry. Not to interrupt, but I did make a payment on April 2nd, 3 days before, 4 days before I was arrested. And then I did post the cash bond. I did have to borrow some of that money. But yes, I did post the cash bond, and I had made a payment.
Hold on. Are you current on your support?
I'm not sure what current would be. I do have rearages, and I believe that's what this case was surrounding.
Okay, I understand that, but are you currently paying your support?
Yes, I'm currently paying on my support. Yes,
He
sir.
is
And I did
not,
just make a
Judge.
payment April 2nd.
Judge, he made a $270 payment on April 2nd. His monthly obligation is $390 for 3 kids. And before that, he hadn't made any payments since October of 25. So he needs to pay as ordered. He didn't pay as ordered in April, and he needs to pay as ordered in May.
Sir, so
And I
you
promise
haven't
I'll do
paid,
so.
hold on. Have you paid your support obligation for April? And
Yeah, yes, I made a payment.
hold on. Before
Sorry.
you answer, I will call the friend of the court while you're on your way to my courthouse, because I'm not going to let you appear via Zoom if you're violating the condition of your bond. Now you can answer my question. Have you paid your support obligation for April?
I'll be honest, sir. I don't honestly know when that date is due. I just know that I did
All
make
right,
the payment.
so here's what we're going to do. I'm going to pass this matter. I apologize, Mr. Attorney General.
Sorry
but
for
I'm
being
gonna
confused,
with
sir.
this. No, I want you at my courthouse now. Because that's part of your bond condition that you're to pay your obligation. You get down to this courthouse, bring me receipts for the payments you say you've made. I'll expect you here, and that way Mr. Attorney General, you can set your schedule. I'll expect you here by noon.
Sir, I'm on, sir, if I could please, I'm 3.5 hours away. I can't physically be there by noon.
3.5 hours away? All right, what time does that make it? 1:30, 2 o'clock. I'll be still here.
Judge, I will be on a plane at 2 o'clock. Judge,
He'll be
he
at
has,
Could I say sorry for the
Somebody-
confusion, sir? I just don't
He needs to
understand
pay
some
his
of it.
support obligation. Somebody needs to bring, all right, we'll do it this way. You don't need to come down. You need to, what's his monthly obligation?
390 and he's paid 270 so far, and he has until the
I
end
can
of the month.
complete that
so he-
today, sir.
All
I
right,
just
so
didn't,
here's
I
what
will
we're gonna
complete
do.
that, sir. I
Oh,
promise you.
Okay, so here's what I'm going to do. You need to make that payment, get that receipt to your attorney. They will have to the end of the day to get it to me. If I don't get it, I'm issuing a bench warrant.
I completely understand. Sorry for some of the
That's
confusion,
out.
sir. I'm not.
Okay, and then we'll come get you 3.5 hours or not.
I understand. I'm
Thank
just sorry
you.
for the confusion, sir. I'm not. I'm not.
No,
versed
I'm
in
not
some of it.
confused at all.
Judge, what is the adjourn
And-
date, please?
And the adjourn date, I don't even know now.
There isn't one.
I didn't put one?
Nothing.
I did nothing. All right, we'll do it on the 14th. 14th, 9 a.m. His bond at this point will continue. We will check over with it. We already did.
On April 7th.
It was the check for the bond cut on April 7th, so it should be on its way over.
Very well. Thank you very much, Your Honor.
Thank you.
Thank you, Your Honor. I'll forward that email to the court once I receive it.
Yes, please do. Court calls case, People versus Michelle Schaffner.
Your Honor, Raymond Cook for the people.
Morning, Your Honor. Christina Costantino appearing on behalf of Ms. Schaffner, who is appearing via Zoom. Ms. Schaffner, can you please unmute and state your name for the court?
Johnson said you were really short.
Michelle
I don't know why he said it.
Not wrong.
Yeah.
It's okay.
Minding your own business. He said she's short.
It's okay. Facts are facts, Jeff.
I know.
All right.
All right. Saying what I heard. You there? Sorry,
Ms. Schaffner, can you state your name for the court?
Michelle Schaffner.
ma'am. You're requesting an adjournment.
Yes, Your Honor. This is a date and time set for PCC. I was recently appointed. There's a significant amount of discovery in this case that I need to review with my client. So we would be asking for an adjournment of the PCC.
May 21st. Will that work for?
Yes, Judge.
21st, 2026, 9 a.m. Bond continue.
And Your Honor, I would like to brief bond. I know she's out, but
Go ahead. We can.
no. We
Go ahead.
don't want to. Definitely. We would be asking the court to allow Ms. Schaffner to leave the state of Michigan to travel to Atlanta, Georgia. She would be traveling from May 22nd to May 25th. She would be going to her cousin's high school graduation, and she would be traveling by airplane and returning on the 25th.
This before with her? Or is that somebody else going to Atlanta? Maybe.
Popular play.
Not really. 22nd through the 25th.
Yes.
Does that include your travel days, ma'am?
Yes.
Does. Any objection from the people?
No, Your Honor.
Defendant may travel to Atlanta, Georgia, May 22nd through the 25th.
Thank you very much, Your Honor.
Thank you.
Okay. Thank you. Bond will continue otherwise.
Thank you.
Court calls the case of the People versus Kenyatta Johnson.
Your Honor, Raymond Cook.
Good morning, Your Honor. Christina Saxon for Ms. Johnson.
Oh, this is the co-defendant. All right.
Yes.
Good morning. And Ms. Johnson, can you state your name?
Kenyatta Johnson.
All right, what are we doing?
We're asking for an adjournment, Your Honor.
Probable cause conference will be adjourned to May 21st, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Andrea Tippins.
Morning, Your Honor, Raymond Cook for the people.
Good morning, man. Please, Honorable Court, Kareem Johnson, on behalf of Ms. Tippins.
Your name?
Andrea Tippins.
Thank you. All right, what are we doing?
Your Honor, we ask that this matter be set for exam.
You have all the discovery.
Yes, Your Honor, I do.
And who are their witnesses available to 12?
We'll do our best, Your Honor.
Yeah, and I have a matter May 12th, a final pretrial in Ingham County.
Any objection to the 19th?
None from the people.
Will that work for you?
That should work, Your Honor.
So preliminary examination was set May 19th, 2026, 9 a.m. before Judge Garwood. So I gave him a week because he apologized to Constantino about the short term. All right. Bond will continue. Thank you, sir. Court does call the case, People versus Phoenix Warrants.
Morning, Your Honor. Raymond Cook.
Good morning, Your Honor. Christina Sackman with Phoenix Bourne. Mr. Bourne, take your name for the court.
I'm sorry? You're muffled.
Phoenix Boards.
Thank you. All right, what are we doing?
Your Honor, prosecutor still has some discovery that they need to send to me, so I'm asking for a PCC.
Sounds to me like you said there was some discovery that's still missing.
Your Honor, we received a new report yesterday. I marked that for discovery yesterday. I don't know if it's been sent to Ms. Sack. I have that report. Obviously, I think she needs some time to review that because we haven't given it to her yet.
All right, got it. I'll adjourn the matter May 21st, 2026, 9 a.m. Bond continued. Thank you.
Thank you.
Court calls case People versus Gerald Casanova.
Morning, Your Honor. Raymond Cook for the people.
Good morning again, Your Honor. Christina Costantino appearing with and on behalf of Mr. Casanova in case number ending in 0340.
And Assistant Public Defender Jay Dollinger on the matter ending in 2130. Mr. Casanova, can you please state the record?
Gerald Casanova.
Thank you. What are we doing?
Your Honor, discovery is complete as to my knowledge, and we would be asking to have this matter set for preliminary examination.
Would echo that.
Preliminary examination. People have their witnesses available to 12.
For best, Your Honor.
Preliminary examination will be set May 12th in both matters, 2026, 9 a.m. before Judge Moore.
Thank you.
Thank you very much, Your Honor.
Bond continued. Court calls the case, People versus Rayvon Reed.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Christina Sackman for Rayvon Reed.
Reed, can you state your name, please?
Rayvon Reed.
Thank you. What are we doing?
Your Honor, Mr. Reed is still in treatment, and I'm asking to set this for preliminary exam because of an additional week to give him time to complete the program so he can be present.
So when does he complete the program?
It's 14 days, so he'll be done
By
the middle of
14th.
next week.
15th. Okay, I got it. People have their witnesses available the 19th.
We'll do our best, Your Honor.
Preliminary examination will be set May 19th, 2026, 9 a.m. before me. Bond continued. Thank you. Court calls the case, People versus Nell Wall.
Yeah, good morning, Your Honor. For the record, Kerry Jensen, 70773 on behalf of Mr. Wall, who is approaching. Sir, can you state your name for the judge?
Lionel Wall.
Thank you. Your Honor, good morning again. Your Honor, in this matter, I've had an opportunity to speak to Mr. Wall. I was just retained on the case about a week ago. And in talking with him and the prosecutor, I would be asking that we refer this matter for a competency exam.
Okay. Missing a forensic examination. I'll need an order.
Yes, Your Honor. I've talked with your clerk and she's advised me to send that over.
All right. Forensic examination will be ordered. I'll set a competency hearing for July 30th, 2026, 9 a.m.
Thank you, Your Honor.
All right. Bond will continue. Thank you.
Thank you. Good to see you, Your Honor.
Seeing you. Court calls case People versus Morgan DeLander.
Rubio, on behalf of Ms. Delandis, she is quickly approaching. Please state your name, ma'am.
Morgan Jelena.
I just wanted to indicate that I am standing in for the attorney of record, David Burgess, with her consent. Is that correct? And I have a request for an adjournment. Mr. Burgess would like an opportunity to discovery and possibly speak to the prosecutor about this case. I'm asking if it could be May 14th.
That objection, probable cause conference will be adjourned May 14, 2026, 9 a.m.
Thank you
Bond will continue. Thank you.
so much. Would I be able to also have Jennifer Robinson called now?
Been here before, right?
Yes.
So in which of 9 realms do you get to call your own case?
I just figured because I'm standing here and my client is here. I just thought I'd ask. So no is the answer, right?
Thank you. Court calls case People versus Daenerys Williams.
Morning, Your Honor. Sam Bernstein with on behalf of Mr. Williams.
Your name?
Daenerys Williams.
Thank you.
We're just waiting on a last piece of discovery, Your Honor. I was told that it was getting put in the mail today by the previous counsel, so hopefully I should have it pretty soon.
All right. Probable cause conference will be adjourned until May 14th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you. Thank you, sir. Court calls case People versus Jennifer Robinson.
Why don't you just walk down?
Who? Good. Yeah, come on up. Yeah, come on up. She wanted her case called and then she left. I know, you know.
Down this side of it.
Did you find her? So we called her case, interrupted the whole procedure. Her case happened to come up, and now she's not here.
I'm here.
No, you're not in any trouble.
Okay. I mean, I am, but
Attorney is.
that's all here.
And have a seat. As soon as so we take her into custody. Case called back up. Thank you. Court recalls the case People versus Stefan Bruce.
Morning again. People. Back old seat.
On behalf of the defendant, Mr. Allen.
Your name?
Stefan Bruce.
You're waiving your right to a preliminary examination?
Yes.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. People also waive their right?
Yes, Your Honor, if there was an offer sent, if I may put that on the record.
Yes, you may.
The offer was to waive up until you guys charged under HYTA.
And I understand that'll be kept open at least until pretrial and circuit.
Preliminary examination having been waived, defendants found over on counts 1 and 2 with 3 and 4 following. Mr. Golson.
Your Honor, we acknowledge receipt of a copy of the information. My client waives its reading, stands mute, asked that a not guilty plea be entered.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
June 3rd at 1:30 with Judge Conley.
June 23rd, 2026, 1:30, Judge Combs.
Thank you, Your Honor. See you later.
Bond continued. And they're gonna need. Court does call the case, People versus Jennifer Robinson. again.
Mary Rubio, on behalf of Ms. Robinson,
Finally,
I'm sorry.
finally, no, you're here. Your client was up here all like morning. To pass it, send her back, called it again, Jen, you had to send her back. He's been like getting her steps and waiting for you.
Okay,
All right? That's how I saw it. I don't know.
okay.
All right. Go ahead.
I'm standing in for attorney of record Dave Burgess. Is that okay with you, Ms. Robinson? We are also asking,
Yes.
Yes.
Okay, go ahead.
we're also asking for an adjournment to May 14th.
Probable cause conference, May 14th, 2026, 9 a.m. Bond continued. Thank you.
Thank you.
Court calls case people versus Karan Johnson.
On behalf of you,
And good morning, Your Honor. Robert Ellman with and on behalf of Mr. Johnson.
Mr. Johnson, can you state your name, please?
Karan Johnson. How you doing, Your Honor?
All right, good morning. What are we doing?
Your Honor, we are waiving exam today. The people have extended an offer for my client to plead at circuit court under HYTA, and we would like to take on that and waive his exam. And I would like to address bond when appropriate.
Mr. Johnson, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on the single count. Mr. Alman.
Thank you, Your Honor. Mr. Johnson is currently on a, oh, I'm sorry. We do waive any formal reading and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Free trial will be set for June 24th, 2026, 1:30, Judge Conlon. As to bond.
Thank you, Your Honor. Mr. Johnson is currently on a GPS tether. He has been on bond since, I believe, January 30th. There have been no bond issues. I know we're close to a resolution in this matter. I would ask that the court remove the GPS tether requirement at this time.
Response.
Some I would object to that. I would ask for this to remain in place at least until such. Yeah, I consider given the facts, this case involving the defendant pointing a gun at the victim and being on a picture holding the gun at the victim.
Got it. I'm not gonna change his bond conditions. You certainly can raise that before Judge Conlon, but I'm gonna leave his bond with the tether in place.
Thank you. Have a good day.
You too. Court calls the case people versus Hussein Alejandro.
You just stepped out with Mr. Teacher.
And is that not behalf?
Stepped out with Feaster.
Apologies, Judge. I assume you called Mr. Say your last name?
Al-Hajam.
Al-Hajam? Hands up the clock. So Attorney Feaster, Assistant Public Defender on behalf of Mr. Al-Hajam. Mr. Al-Hajam, please state your name for the record.
Hussein Al-Hajam.
All right, what are we doing?
I was just talking to Mr. Al-Hajam.
I know, because you told us you were.
Yes, Judge. My apologies.
No, I don't accept your apology.
Oh, I'm sorry. That's disappointing. Hurt my feelings.
Well, sir, I'm not mad at you. I'm mad at him.
Yeah.
No? Okay. Just so you're aware.
I think he would like to set this matter for preliminary examination, please, Judge.
All right. So is all discovery complete?
As far as I know, Your Honor.
All right. I didn't have to go through that last. I just went through. Would people have their witnesses available on the 12th? Preliminary examination will be May 12th, 2026, 9 a.m. before Judge Washington.
Sorry again, Judge.
No, you're not. Fine, continue. Thank you, sir.
Thank you.
Court calls case of the people versus Jeffrey Ball.
Hang on, really quick.
Stephanie Cannon on behalf of Mr. Ball, who's approaching. Ms. Ball, you're at the lectern. Please state your name for the record.
My name is Jeffrey Ball. All right, I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of aggravated assault. The 1-year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. That is the court's full understanding.
Try to ask my full understanding of the agreement.
All right, may I have him sworn?
Right here. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth of the God?
Yes.
State your name.
My name is Jeffrey Ball. All right, sir, it is this court's understanding that you're going to plead guilty to the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court cost. Do you understand that? Yes. Right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Perry in the 15th District. Yes, I understand. All right. Still wish to plead guilty? Yes. To that charge, how do you plead? I beg your pardon? Guilty. Oh. You understand that by pleading guilty, you'll not have a trial of any kind? Yes. You signed an advice of rights form, is that correct? Yes. Any question regarding any of those rights? No, Your Honor. All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. Understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Yes. Understand you're giving up your right to appeal of right? Yes. Are you on probation or parole? No, sir. Has anybody promised you anything other than what's been stated here today to get you to plead? No. Anybody threaten you or coerce you? No. You're doing this voluntarily? Yes, I am. Pardon? Yes, I am. And of your own free will? And because you believe that you're guilty of this offense? On the date of November 16, 2025, at the location of 211 East Davis Avenue, Apartment 12, City of Ann Arbor, Washtenaw County, State of Michigan, what did you do on that date involving an Andrew Sirotowski? You want me to explain? Well,
Did, if I may, on that date in question, did you have a physical altercation with him?
yes.
As a result of that physical altercation, did he go to the hospital?
I don't know if you went to the hospital or not, but
Do
that's
you,
what it turned out. Yeah.
based on the police report, and you became aware of the fact that he wound up hospitalized as a
Yes.
result?
Yes. Sir, if I accept your plea, and you did this intentionally, is that correct, sir? It's a violent, yes. All right. Sir, if I accept your plea, if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would first of all not be permitted to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir? Yes. Counsel aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
I'm aware of none, Your Honor.
And have I complied with the quote?
Yes, Your Honor.
The court has, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Since investigation and report is ordered at 15th District Court probation, sentencing will be May 29, 2026, 8:30 before Judge Perry. Bond will continue. Thank you.
Thank you, Your Honor.
You. Court calls case People versus Dion Baldwin.
Bring cook to the people.
And Assistant Public Defender, Tanaka Kirass, Your Honor, on behalf of Mr. Baldwin, who's approaching. Mr. Baldwin, state your name for the record, please.
Dion Baldwin.
But we're asking for an adjournment in this matter. Okay, give a moment.
All right.
Judge, this matter was set for a competency evaluation. The report did come back finding Mr. Baldwin. You don't have that. It's not written on here, but
The report came back?
yes, Your Honor. Maybe 2 weeks ago. Yes.
I don't have the report.
No? Okay, well, we would be asking for an adjournment.
Yes. What was the finding? Well, hold on. I have a February report.
The report that we have had a finding of incompetency, but restorable within the time frame. Is that what yours says, Judge?
Well, the report I'm looking at is dated in February.
I don't think
Your Honor, based on the notes that I'm seeing, it looks like that's the most recent report that we have. It looks like the past couple of times that we've had this case, the defendant has refused to.
Refused to come up. Got it. That's why we're out. Got it.
So, Your Honor, my client would like to challenge that report, so we're not prepared to stipulate to that. I've explained to him that there is a process that we would have to go through to challenge that. He wants me to ask the court for an immediate finding of competency.
Which the court can't do because the only thing I have before me indicates that the defense is confident. But he's permitted to challenge that finding. Are you going to have? Are you seeking?
Consensus is that.
Are you going to be seeking your own independent evaluation prior to the hearing?
Well, Your Honor, he's telling me now that he would like to stipulate to the finding, but I'd be more comfortable if we just put it out 1 week so I can ensure that he understands what he wants to do.
Okay. I'll adjourn the hearing to May 7th,
Okay.
2026, 9.
Thank you, Your Honor.
Court calls the case of the people versus our Sean, is it Bangoria?
That's correct, Your Honor.
People.
This Assistant Public Defender Jay Dollinger on behalf of Arshan Bangora, who could be an appearance via Zoom, Your Honor.
State your name.
Arshan Bangora.
Thank you.
Your Honor, I have, I was reaching out for additional discovery in this matter. I was just informed yesterday that there is no additional discovery. So I would just need a couple weeks to discuss that with my client to see what next steps are.
Probable cause conference, May 14, 2026, 9 a.m. Bound continued.
Your Honor, if I may briefly on bond modification. Mr. Bangora has advised that he's been on Tether since February. He's had no issues at all. He stays locally in Ann Arbor with his mother. He has her support. We would be asking for consideration to have that Tether removed at this point.
Response from the people. That's okay.
It changed things on this, so now it's taxes in one spot. Understanding is that the defendant recently, when this case was initially charged, had gotten off of juvenile probation with the defendant for charges of CCW and possessing a machine gun conversion device commonly known as a lock switch. And that was part of our reason for requesting the tether. I would request that the court continued. Don't think he had any money to post. I think we wanted a PR, but we did request that.
Yeah, they're and you got the PR. All right, I'm under those circumstances. I'm going to deny the request. Okay, let's see where we end up.
All right, thank you. Mr. Bangora, I don't know if you heard that, but the judge has denied that bond request at this time. You and I will talk.
All right.
All right, thank you.
Thank you, Your Honor.
Thank you. Bro, I ain't gonna lie, nigga.
Yeah. Right. Recalls the case, people versus Martel.
People, Your Honor.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Martel, Judge. Your Honor, thank you for passing this matter. State your name, Mr. Martel.
Angel Martel.
Your Honor, thank you for passing the matter. I have a chance to discuss our case a little more with Mr. Martel. I'd ask the court to adjourn this matter 1 week before I take action either way in dealing with moving the case along. I'm asking for 1 week in that I've already prepped the case and I have had a chance to meet with Mr. Martel, albeit truncated. I will go visit him this weekend.
May 7th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Court calls the case People versus Michael Brown.
That's developed for the people.
Assistant Public Defender Dottie Lebo, behalf of Mr. Brown. And I give a green sheet. I've discussed this matter with the prosecutor. She's requested some additional mitigation information, which I'm going to be seeking to provide to her.
Additional mitigation information.
Yes, Your Honor.
I'll adjourn this matter to May 21st, 2026.
Thank you.
Court calls the case of the People versus Travis May.
That's developed for the people.
Morning again, Your Honor. Edward Dukes on behalf of Travis May.
Your name, sir? Travis May.
Well, my people, as well as me, to review these reports, they do appear to reflect out of custody behavior of certain people. At this time, I'm not sure what defense counsel wants, but I think it will be to adjourn.
I previously turned in a green sheet. I did have the previous bond violation. I was able to review the two new ones with Mr. May. The green sheet, there's some ongoing negotiation. He does have an arraignment on a new matter that is set for tomorrow.
Got it.
That would be a misdemeanor. And I'd like to address bond just briefly on a release to treatment.
Well, I'll adjourn it out. I'm not going to do anything pending these bond violations. Regarding his bond. I can tell you that, and inclusive of release, at least at this point. I think we need to figure out what's going on. All right, but what do you want? I'm gonna do something else. Can we talk about what I'm gonna do? What new? George.
Your Honor, I'd ask for a short adjournment so I can figure out a direction.
May 14th, 2026, 9 a.m.
Thank you, Your Honor.
His bond will continue, I believe, as.
Thank you.
Court calls case People versus Jonathan Carey.
Assistant Public Defender Dottie Lebo, Mr. Carey. Your Honor, if we could pass. I just got a text from Mr. Carey that he needs me to send him the Zoom link once more.
Your Honor, I'm on.
He's right here.
Oh, excellent.
Need you to do anything. He figured it out on his own.
Fantastic. Your Honor, we're going to be requesting an adjournment. We're still negotiating.
Probable cause conference, Mr. Carey. I'll adjourn it out to May 21st, 2026, 9 a.m. Okay?
Thank you, sir.
Thank you.
Thank you, Your Honor.
Court calls case of the People versus Taiwan Griggs.
And Stephanie Karen on behalf of Ms. Approaching, Your Honor. See your name.
Come on, Griggs.
All right, go ahead.
Your Honor, I am in receipt of a competency report indicating that my client is now competent. As a result of that competency, we're going to ask for a PCC.
I thought it was.
Thought it said competent, the one my sentence, but competent, right?
He's no longer incompetent.
Yes, he's
So
not.
he's competent to stand trial.
Yes. Yeah, and we are so stipulating to the report. Yeah, yes, and we are so stipulating.
I've also received the report that the defendant has been restored to competency, and I would also support to accept it and also stipulate.
Okay. We'll get a deal.
Court will indicate that upon review of the reports, the court would find defendant is now competent to stand trial. That specifically the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant competent. I will sign an order once I receive them. I believe this was a request of the Public Defender's Office to move this up. Judge Washington contacted me so it could be heard, which is why it's set for today, but I do need an order finding them down.
And Your Honor, I will prepare one for the court and get it. Your Honor, in this particular matter, my client would ask me to address bond.
I gotta set it for something else, so.
Yes. We're asking for a probable cause. Upon a finding of competency, Your Honor.
What are you doing?
You found him competent, correct?
I did.
Okay, so we just
No.
are asking for our next probable cause date from the court.
Well, originally, I think this came off of a PE.
Yes.
Yes, Your Honor. So the case was set for a preliminary exam but as a result, he had new additional charges come through. I need to see if we can get a global resolution.
New charges?
Prior to when the PE was set, after the PE, due to circumstances and situation and his mental health at the time, he did get a new charge. But I just want to see if we can wrap this up globally. So I'm asking for a PCC date to see if we can get a global resolution.
How much time do you need?
Your Honor, just a 2-week adjournment. My client is eager to move.
2026, 9 AM.
Thank you. And Your Honor, in addition to that, my client is asking if he could be released to treatment. When he was in treatment, he was actually doing really well. They were helping monitor his mental health. Substance abuse is an issue. After he left sober living, that's when things kind of went downhill.
Off the rails.
And I understand.
Is there gonna be any objection to release to?
I'll leave it in the court's discretion.
I'll do it.
All right, I'll sign the standard order allowing release to inpatient treatment with a GPS tether.
And I'll have that to the court shortly.
All right, along with the order regarding competency.
Yes, Your Honor.
All right, at this point, it's about, we'll continue.
Good.
Court does call the cases of the people versus Castilian, Cotton, Roberson.
Assistant Public Defender, to carry out the rule, Your Honor, on behalf of Mr. Cotton Roberson, who is on Zoom.
Yes. Sir, can you unmute and state your name?
Castellion Cotton Robertson.
Thank you, sir.
Judge, I think I.
Look for your stat green sheets. Is that what you're looking for? So, walking up out, I was kind of shocked. They have them folded out like a deck of cards.
I just don't know what happened, Judge.
No? I know you had them. What are you asking for while you try to locate your green sheets? Those belong to somebody else. What are you asking me to do?
Your Honor, 2 weeks will be fine. We're just gonna, yes, Judge. Please.
All right, sir, I'm going to adjourn your matters out to May 14, 2026, 9 AM.
Thank you.
Thank you. Bond will continue. Are you gonna do new ones? We're coming to buy stock in green paper. Court calls the case, people versus Jason Maple.
Morning, Your Honor, Raymond Cook.
Morning, Your Honor, Joy Mason, Assistant Public Defender, representative.
Jason Gary Maples.
I have before me a plea sheet that indicates that the defendant is going to be pleading guilty to count 2, stated count 2 of retail fraud 3rd degree, and an added count 3. No, an added count 3 of attempted resisting and obstructing a 1-year offense. Upon a successful plea to counts 2 and 3, count 1 would be dismissed. That's the court's full understanding of the.
That's correct, Your Honor.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give? That's what true self you got.
Yes, sir.
State your name.
Jason Gary Maples.
Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
Yes, Your Honor.
First is the stated count 2 of retail fraud 3rd degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost, fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Sure.
You understand? And then also then count 3, which is attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Garwood in the 15th District Court.
Yes, Your Honor.
Still wish to plead guilty?
I still wish to plead guilty.
To the charge of retail fraud, 3rd degree, how do you plead?
Guilty.
Charge of resisting and obstructing, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Signed an advice of rights form.
Yes, Your Honor.
Any question regarding any of those rights?
Oh, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, I'm in Judge Kunke's felony drug court.
Okay, were you
I've
on probation at the time of this offense?
Yes, and I pled guilty to my violation already in the court.
Okay.
Court.
I do have to advise you, because I'm not sure of that, but I do have to advise you that this could be considered a violation of that probation. And that,
Yes, Your Honor.
and it is that court could sentence you to the maximum allowable under
10 years.
other charges. You understand that?
10 years. Yes, Your Honor.
You still wish to plead?
I still wish to.
Plead to these charges? Anybody promise you anything
Oh,
else
Your Honor.
than stated here today to get you to plead?
No, all me.
Anybody threaten you or coerce you?
No, Your Honor.
Doing this voluntarily
Yes, Your Honor.
and of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty?
I am guilty. I did those offenses.
March 29, 2026, at location of 231 South State Street in City of Ann Arbor, Washington County, State of Michigan. What'd you do at the Target store that makes you think that you're guilty?
I took alcohol, and on my way out the doorway, I took some coffee and I took some paper towel and I threw it out the door to make it look like I didn't take any alcohol. I'm an alcoholic. My sister committed suicide back in December, and I'm really struggling with drugs and alcohol. I'm doing well in drug Kunke's court other than what's going on, and I hope to have another chance at drug court.
Okay. And when you did this on that day, the store was open to the public at the time?
Yes, Your Honor.
You didn't have anybody's permission to do that, take that property out, did you?
Not at all, no.
The property you were attempting to try to take out of the store was offered for sale by Target?
Yes, it was for sale.
All right. And did police officers arrive?
Yes, I threw the alcohol down in front of them and walked up to approach them. I believe my recollection. When they approached me, I believe I had the alcohol in my hand.
And so, all right. And then did you attempt to what'd they tell you to do?
Everything happened so fast. I just remembered that they grabbed me. They told me why obtain and
okay.
I have limited record.
Follow all of their commands?
Yeah. Oh, yeah. Well, I believe the RNO happened. He was accidentally on my foot, and
what?
He was stepping on my foot on accident. So I pulled my foot back, and when I went back, I accidentally kicked him in the leg. That was the RNO.
Okay, so
I didn't just go up and kick the officer in the leg or shin or anything like that. It was a misunderstanding, really. But I did resist. I was so out of it. I was licking the front of the patrol car. I was off of medication and under the influence.
Okay. So the officers are trying to take you into custody.
Yeah.
And in some way I wasn't cooperative with them in terms of getting you into custody.
Correct.
Part of that being the licking of the car, the kicking of the officer.
Yes.
That kind of thing. You just weren't being cooperative.
No.
All right. So I do have to advise you that if I accept your plea between the time of my acceptance of your plea and the time of sentencing, if you commit additional misconduct that's divided in Michigan court rules, this court or Judge Garwood would no longer, you could not withdraw your plea and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements?
No, thank you, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes.
Court will accept the defendant's plea guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
May 26th at 9 a.m.
May 26, 2026, 9 a.m. That is before Judge Garwood. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you.
Thank you. very-
Welcome, everybody.
This. What? Shanaza? I don't even know what case it's on. Just, it's gone. Okay. Yeah, let's see if we can get it to catch up. That file is so long. No, you're not. Court calls the case, People versus Mario Crawford, 2 cases.
Morning, Your Honor, Raymond, people.
Assistant Public Defender Davy Lebo for Mr. Crawford, who I believe is appearing via Zoom from home of New Vision.
Crawford? Oh. Mr. Crawford? Oh, he's there. Sleep. He's sleeping.
I thought that was a still image, Your Honor.
Don't think so. Client sleep.
Oh. Yes, Your Honor. Because he's home to New Vision, I can't directly call him. So
what?
Because he's home to New Vision, I don't have a direct number for him that I could use to awaken him.
Oh no, I think he just hold it. Oh, no. Hang on. Mr. Crawford? Hey, unmute. State your name. What's your name?
Mario Crawford, sir.
All right. You have a good nap? It's okay. No, it's okay. Don't even worry about it. Okay. You're asking for an adjournment?
Yes, Your Honor. My understanding is Mr. Crawford is going to be at home New Vision for the next 20 days.
20 days? Okay. So if I put him out to the 21st, will he be out by then or?
I believe so, Your Honor. My understanding, there is a potential for extension.
Let's try that then first. Let's put him out May 21st, 2026, 9 a.m. All right, Mr. Crawford. Thank you.
Thank you.
Court calls the case, People versus Jeremy Davis.
People.
And good morning, Your Honor. Assistant Public Defender Chinazi Kiriak, really on behalf of Mr. Jeremy. Take your name for the-
Jeremy Davis, thank you. No, we'll wait.
Your Honor, we would like to set this matter for preliminary examination
All discovery is complete.
to our knowledge, Judge.
Other witnesses, the 12th.
Your best, Your Honor.
Preliminary examination will be set May 12th, 2026, 9 a.m. before Judge Moore.
And bond, Judge.
The same.
I did not hear you. May
I was going to say the same. You're asking to address it.
That is correct.
Right, go for it.
Your Honor, we're asking for a personal recognizance bond in this matter. Mr. Davis, he is in front of the court in custody because he missed his last preliminary examination. I believe there may have been 2. Now,
What?
preliminary examinations that were missed
By him.
by him. Yes, Judge. Mr. Davis.
You're about to ask me to set it for preliminary examination.
That's correct.
And you're asking me then to let him out so we can have the trifecta.
We're hoping.
Oh, no, go ahead. I'm
Get to that point.
headed in your argument.
That's, we're hoping it doesn't get to that point, Your Honor. I have had very, very stern words with Mr. Davis, and I've explained to him, I said, I don't know why, the court would allow us to be released if we are not going to come to court and just do the same thing over again a third time. He has assured me that that is not the case. He's put some things into place.
That after the first trip?
So the first time, Your Honor, he indicates that he reported to his attorney that he did not have transportation. He would not be able to come to court because he was living all the way in East Point, Michigan. He just had no way to get all the way out to Washtenaw County. I think that we were able to get a warrant recall in place, which is what allowed him for that second opportunity. And the second opportunity, he had secured housing here, but unfortunately that had fallen through. And then he was once again found himself in Detroit. He states now, and I've explained to him, there's the Delana Center. There are a number of places that he can stay, and he needs to make sure that he remains local. If he has to sleep in front of the courthouse before his date, they may kick him out, but at least, you know, he'll be here, Judge. So he's asked, says that he has a place to stay now. And if that is not able to work, he will stay at the Delana Center and do everything in his power to ensure that he's here for his next hearing.
I don't need a response. Motion for bond reduction is denied. Bond will continue.
Okay.
Was it freedom? Thank you. Court calls case of the people versus Dion Bird. 2 cases.
Hi, being senior assistant public defender representing the neighbor.
Yeah, Burke. Morning.
Are requesting a preliminary examination in restaurant.
Okay. There was a communication sent to the court. I don't know if anybody else got it. It's from his grandmother. So I'll make sure you're provided that.
Yes, thank you.
You want preliminary examinations in both of these matters?
Yes, please.
People have their witness discoveries complete.
That is my understanding.
We'll have their witnesses available to 12. All right, I'll set preliminary examination on both cases, May 12th, 2026, 9 a.m. before Judge Moore as the bond.
Your Honor, if I could, in terms of the court date, when we were here last week, we conveyed that Mr. Bird has a matter where he is the victim and he needs to be in court, I want to say on May 6th. So we were hoping that we
May
would.
6th?
Let me check the date. But we were hoping that we could possibly have the preliminary exam this coming Tuesday in order to try to facilitate him being,
I understand that, but I don't, are the people gonna have their witnesses by? What, I don't. Well, they'll get him here. If he's a victim on a case, they'll get him up here. I don't think it should hold up anything.
if we can, well, let me address that. If he's able to.
Go ahead.
Your Honor, Mr. Bird is a lifelong resident of Michigan. His grandmother is here present in the courtroom. I did get to meet her just a few moments ago. He grew up in this area. He's a member of longstanding at St. Paul Missionary Baptist Church. He has an operating engineers and laborers card such that he had recently started working at the battery plant on Ann Arbor Saline Road. They are holding his job for him until today. You're requesting, and upon learning that there was a warrant in the course family law case, he did come to Washtenaw County and turn himself in order to take care of this matter. He is not a flight risk. He has long-standing relationships with this county and this community, and here in the state of Michigan as a whole. He indicates that he has in the past appeared for court dates, this reauthorization cases. The majority of the allegations are from 2024. The supplemental refers to text messages from 2025. With that, we would ask that the court consider a personal recognizance bond or a low cash bond and continue to have his employment and to appear in the case where he is the victim, as well as here for this.
All right, response.
Your Honor, I'm gonna continue our objection from the last hearing. The court is aware that there was that report from December of 2025 that involved text as well as it being a progress. So this is why I'm just gonna continue my previous objection.
Right, and some of the information that is in the letter relates to those texts and that, but I'm not gonna consider that what was sent. I think it's appropriate that at this point, his bond just continue as is. I deny any request for any change to the bond. I will, as this set his preliminary examination for May 12th. 9 a.m. before Judge Moore.
Thank you.
Court calls the case Bureau versus Sadie Hall.
Your Honor, Raymond Cook.
Michael Gaddy, Assistant Public Defender for Ms. Hall.
Thank you. Can you state your name, please?
Sade Renee Hall.
Thank you. What are we doing?
Your Honor, looking at this file, it looks like when Ms. Hall lost contact with the court previously, there had been a competency, an order for competency evaluation that was not, I don't think the evaluation had occurred. I did have a chance for this is an old case, but I think it would be prudent to have her evaluated.
Any food for nothing. Like I only ate breakfast. They're not giving me or serving me any food because they barely cook at this place. They serve food when it's time to eat, and I didn't miss any food. It's only 11:26. I think we eat at 12 o'clock or 11:30 or something like that. I only have breakfast. It's time for lunch, and I want to eat. And they got me to work, and they don't let me take showers because the women here don't like me. They don't let me.
All right. So I'll order competency and
I have prepared an order.
Have an order.
If I may.
All right.
They want us.
I'll have a forensic. I'll sign that. And then I'll set it for a.
I lost so much weight in the face. My mama looking at me like I look terrible because they don't feed me a lot of food.
I'll set a competency hearing for
And I want to
July
move nursing home on 70.
2026. Yeah.
Thank you.
Thank you.
Come on.
Court does call the case of the people versus. Oh, there he is. All right, court does call the cases of the people versus Shaquille O'Neal. Tubbs.
Ashley Feltus for the people in all matters.
Hello, Mr. Tubbs. Up, you're still muted there. Hold on.
Into the
I can't hear.
courtroom. Wow.
Pardon?
I said,
What'd you
why?
say?
Can you hear me?
I can hear you now.
I'm saying, why do they have to bring a computer to where I'm at? I'm off text and things of that sort. I'd rather be in the courtroom.
I don't know, Mr. Hold on a moment though.
Okay.
All right. All right. I have the evaluation's currently in progress. We don't have the paper, we don't have everything done, or they don't have everything
Yeah, they was
done.
talking about moving the court date to the 10th of next month.
Yeah, hold on a second. Hold on, Mr. Tubbs. Go ahead.
Joy Gaines, Senior Assistant Public Defender, Your Honor. I received a copy of the letter that was addressed from the Forensic Center.
Yes.
Indicating that they were
requesting.
The process of preparing the report,
That is
we
correct.
don't have.
That is correct. And I think the letter indicated they needed about a month from the date of the letter, and that would be May 10th. So we're asking for a hearing.
The closest to May
We're asking to continue this hearing to the
14th. All right. They're asking for the time. I'm gonna have to give it to them, Mr. Tubbs, for the forensic center or for the evaluator to finish their report. And so that'd be May 14th, 2026. 9 a.m. All right, bond will continue. So hopefully I'll get the report. If Mr. Tubbs, so that you understand, if we get it sooner than that, then I'll move the hearing up and I will set the hearing. All right. All right. Thank you. Bond continue.
Thank you.
Is that it? Really? Huh? I'm so good.
Is that it? He is so good, you know? Nothing quite like Judge Simpson. Ladies and gentlemen, thank you so much for hanging out with me tonight. It's been amazing. I really appreciate all of you. I really give a special shout out to Mary Beth and Wendy Greek. Your contributions do mean a lot. This channel operates entirely contributions from viewers like you. For me, Mama Wolfie and the puppies on the couch and the cat in the chair over there. Thank you so much for hanging out with us tonight. This has been another interesting day of court. And the crazy part about it is that's just the couple hours I've thrown together. There's a lot more where that came from today alone. So keep an eye out. There'll be some more court cases dropping, and we'll have more to watch on Saturday. Come brunch time, you know. Be looking forward to the weekend review. Good night, ladies and gentlemen. Fluffy Fox Game, Felix, my friend, Mama Wolfie, Maybell, Let Go of the Rope, Fat Boy is back, Michael, Rocky, Charlene, Tut, I can't read, it's going too fast, Bobby Smith. All y'all are awesome. You know what? That reminds me. We have another little thing that we like to do. It's a new thing. It's a credit thing. It's working. There we go. Look, there's Mary Beth and Wendy Greek. Amazing VIP. The regular supporters. People who are here all the dadgum time. Marty, you're in there. Kieran, Barry's out there somewhere. I know he is. Michael, Eileen, you should be in the regulars also. Felix, I think most everybody here should be in the regular list. I don't know. I don't even know what separates that. Who knows? Lisa, you were here early. Lisa was an early bird. We all get here a little early and chat. Come by and chat with us early. I do this every single night, 8 p.m. Central, 9 p.m. Eastern. Come on by. Thank you all for being here. I am your humble lone wolf Oosel. I am the guy who gets all these court cases together and puts them together every night. This little compilation where we sit around and talk about court cases. Come on by and hang out with us. We do it every day. Almost every day of the week. We have chats on Saturday night and Sunday night too, but not live. Not quite like it is here now, right? It's been fun, guys. I appreciate y'all. It's been a blast. Oh, hey, and Wolfbot is doing a thing right now. I'm 100% sure, and it's a Mogan thing with Alcium after he'd been in jail for a little while. It's fun. Let's go watch it, guys. Talk to you later. Oh, Wolf out. What, you're still here? There's no more. I told you. We're done. Go. No more. Bye. BLR. Lone Wolf. Oh!